Hi, my name is Jeff Butler. I'm an attorney and also a partner at the law office of Pearson & Butler here in Utah. One of the services we do offer our clients is loan modification services. I'd like to use this video to give an update on some recent legislation that was passed by the Utah legislators. But before I begin, I'd like to start with a disclaimer. The information I'm providing in this video is for general information purposes only and not intended to convey a legal opinion or legal advice for any particular case or situation. Also, this information does not represent a complete discussion of all the issues relating to loan modifications and foreclosures in the legislation. And since every individual's factual situation is different, independent legal advice regarding specific situation from a licensed attorney is advisable. I applaud Utah legislators. They've recently passed new legislation to include foreclosure rescue and loan modification amendments. This legislation in part is due to the challenges faced by Utah homeowners that are being foreclosed on. In 2009, Utah ranked 5th in the United States for filing foreclosure behind Nevada, Arizona, Florida, and California. Under HB 0053, several definitions were modified relating to real estate licensing, including prohibited conduct by real estate licensees, definitions related to mortgage officer licensing, and prohibited conduct by a mortgage officer licensee. I wanted to briefly discuss the grounds for disciplinary action that has just been implemented. First is engaging in a foreclosure rescue if that person is not licensed in the state of Utah. There's a lot of companies outside of Utah that are asking and providing loan modification and foreclosure assistance to people in Utah. If they are not licensed, they're breaking the law and they are subject to disciplinary action under the state's new legislation. Similarly, if a person is offering to do loan modification, they need to be licensed under the Act. Another problem is when a person is requesting or requiring a person to pay a fee before engaging in an act of foreclosure rescue, if the person is required to forfeit the fee if the act is unsuccessful and the person gets foreclosed on anyway. Another area that concerned the legislators has to do with inducing a person who is at risk of foreclosure to hire the licensee to engage in an act of foreclosure rescue by suggesting to the person, the homeowner, that the licensee has a special relationship with the person's lender or loan servicer, or falsely representing or advertising that the licensee is acting on behalf of a government agency, the person's lender or loan servicer, or a nonprofit or charitable institution, or recommending or participating in a foreclosure rescue that requires the person to transfer title to real property to the licensee or to a third party with whom the licensee has a business relationship or financial interest. Or if a company asks the person receiving a modification or foreclosure assistance to refrain from contacting the person's lender, loan servicer, attorney, creditor, or housing counselor. If a person is doing a loan modification and they've hired a third party, it's very important that that homeowner have communication with the lender as well, or the loan servicer. Do not stay in the dark. If you've hired a third party to let you do a loan modification, you need to know what's going on with the bank. I've retained several clients who were at risk of foreclosure after having hired a third party to do negotiations for them, in part because that third party had said to the homeowner, do not talk to the lender. That kind of advice is a violation of law and is considered illegal activity. Also, there's a new amendment as well. Starting May 11, 2010, anyone who is offering a loan modification or foreclosure rescue needs to put in the contract that that homeowner has the right to cancel the agreement within 3 business days after the day on which the person enters the agreement. Having reviewed the amendments, it appears that Utah has made some good headway in helping homeowners have some additional safeguards and protections. There are Utah attorneys that can help Utah homeowners who are struggling to make their mortgage payments as well. This includes helping borrowers get qualified under Making Home Affordable, also known as HAMP, which is a federal loan modification program. There is hope for Utah homeowners through loan modification attorneys. At the law office of Pearson and Butler, our attorneys offer free loan modification consultations. If you are struggling with debt and want to look at the legal options available to you, feel free to give us a call. You can reach one of our attorneys at 801-303-0557. Thank you.